All right, we've got until about 5 o'clock to vote, so we can, I think, get through a good portion of the list that you have before you. And there are a couple of other bills that we are going to add as we go along. But first, we'll start, we're going to start off with Senator Wallstreicher. Go ahead.
Thank you, Mr. Chairman. Senate Bill 613 is the non-consensual towing legislation. We continue to encourage the parties to get together. They did today, and it sounds like they're making progress. I know the Speaker has been very involved in this process and recognizes some of the bad actors who are in the industry that are causing problems for our truckers, many of whom are independent truckers who work for themselves and are not kind of big truckers or moneyed interests. So with that, Mr. Chairman, it sounds like they are on their way to resolution. We'll move the bill at some point, even if they're not able to meet that resolution. But for now, I'd like to hold it one day so that they can continue to negotiate.
All right, Senate Bill 613 has been held for a day. All right, we'll go on to, let's do Senate Bill 777, and that's Jamie, right? Correct. Mm-hmm.
So Senate Bill 777 prohibits an official custodian of records from charging a search and preparation fee under Maryland's Public Information Act for the search and preparation of the first 500 pages of a record for inspection if the record relates to an administrative or criminal investigation of misconduct by a police officer as specified under the bill.
All right, so we have a sponsor amendment.
Yes, Mr. Chairman. So, members of the committee, I thought it was clear from the testimony that there is a problem. There are challenges to entities and people getting the records that they're entitled to get under Anton's law, but I'm not convinced that the bill as proposed is the right solution. I felt like it would be important, and Senator West gets credit for this, for making the suggestion at the time of the hearing, that we should bring the parties together and let them work it out and figure out the best practices for these disclosures and what should be charged and what should not be charged and how to go about it. So I would suggest that we do a task force with the various stakeholders, and that's my amendment. And we talked a little bit about who should be on it, and I thought the people that testified, or at least a representative of the organizations that testified, like the Office of the Public Defender, on the proponent side, one of the advocacy groups, the Maryland Municipal League, and the MACO, and the chiefs and sheriffs would be a starting place, I think.
Excellent. So let's do like this. It's when you're establishing a task force, you got to clearly define the goals of the task force. So what are they going to study exactly? Can you get West as well?
Cost of production of investigatory files and the procedures affiliated with it, meaning there was some discussion during the hearing about, well, they could start with the documents, and then if that leads to the need for a video, they could then go back and make a second request, like the procedures involved in how to go about responding to the request. The best procedures, best practices, I guess.
And maybe a little bit of a report out of how the commission's doing, like how the review commission's doing, the appeal board.
Okay. The compliance board.
The compliance board, yeah. Sorry. Which you appeal your denial decision to, or whatever.
So there were two issues brought up. One is just not honoring the request and not responding, and the other is the cost that's being charged, the disparity in cost. So those are the two issues.
Got it. So then, for membership, you've got, sorry, you had MML, you had MACO, Chiefs and Sheriffs, Office of Public Defender.
And other witnesses that were at the bill hearing. I would say we could pick a member of one of the advocacy groups or that represents the citizens or the people. I don't have a preference.
Oh, yeah.
Oh, yeah.
Maryland DC Press Association.
How about the state's attorneys? They're the ones that maintain the video.
I think, I'm not sure the state's attorneys maintain the video. It's the custodian of the records would be different for whichever agency you're, right?
It's whoever holds
It's
the
whoever's holding
record.
the record.
Whoever maintains.
Yeah, but there's no, like, consistent, like, custodian of the records, you know.
Testimony from
per-
Scott Schellenberg.
the- For, say
On
what?
those videos.
Yeah, they have people that all they do all day long is videos.
No, I understand that, but what happens if it's, the request is from a different
But
agency?
isn't that for discovery in criminal cases, not for MPIAs, for police agencies?
That's what the public defenders are requesting this as part of discovery for Brady.
You still have to expurgate the video. You can't turn video in that has pictures of innocent people or witnesses. So, and that's what Schellenberger's office is doing in Baltimore County.
Who else is on your panel?
I don't think there's any members of organizations you have
No.
that testified from Vault Legal,
Yeah.
and you had someone from the ACLU. So I would say at least one of the advocacy groups.
It's the Press Association.
Yeah, you've got Maryland DC Press Association.
That was, what is,
Press Association.
Advocacy group?
They're not representing the people.
so it's, right now it's MML, MACO, Chiefs and Sheriffs, OPD, the Maryland and the DC Press Association, you're right, state's attorneys. Say what?
Favorable from the FOP Center. They didn't testify, they just put something in writing. I'm going through the stuff now. What's SSJC? Hold up.
Yeah. Say Balt, what is the gentleman, the young gentleman, Balt Legal, or,
Vault Legal, and also this other thing is, so SSJC is Silver Spring Justice Coalition, that man testified.
yeah.
We don't need them on there.
Okay, well, I'm just saying there should be an organization, a representative
one.
of an organization such as that. We can do the Vault Legal, what you wanna do?
It's on the 35th of February.
So are you adding the Baltimore legal?
Yeah, we can add that. Baltimore.
Yes.
They disrespected my chair.
Oh, that's the, oh, okay. That man, though? That man?
Yes.
FOP. How about the state police? I mean, they're a big standalone agency that is different.
I mean, I don't want it to be too weighted in that way, but it looks like it's getting there.
Okay.
All right, then who should staff it? Is OAG? They put that,
They do put
the
a
annual.
book out together, yeah.
All right. So, and then how often are they gonna report? Like,
I mean, once they work it out, they may not need to continue, so I would say
Should be a one-year study.
prior to next session.
Right, December 31st.
so December 31st, 2022. So
Those would
that's
become effective,
October 1st. So,
they, well, you could do June, but then they'd still have to get up and running and do their hearings and then have a report ready by
The election year task force. People love to do those. Jill, I know any Jill.
Do you want members of the General Assembly in that?
Are members of the General Assembly on that? That's a good question.
You always have to on a task force. That was the deal. That was the Mike Miller thing.
I know,
If
that
you
way.
put, if you put in a task force, you better.
You
be
gotta
willing to
serve on it.
I'll be on the task force. Yeah, I'm interested in the issue, so it's not bad.
So 2 Senate, 2 House.
Yeah.
And when do you want the report? Or,
Should probably be
Can I pick
another,
my house member? No, I'm kidding.
talk to the presiding officer about that. I'm sure.
who do you want the report to go to?
Should go to the General Assembly
Yeah.
and the governor.
It's up to you.
Who appoints the task force members and who's the chair?
Presiding officers will appoint, and then the chair, I'm not sure.
You
How's it usually
can
done?
do it however you'd like to do it. It can be the governor can appoint, the task force can select themselves.
Presiding officers could choose?
Okay.
What was the consensus?
Presiding officer. So the reporting, you wanna do this it's gotta be, there's not enough time for this one. Do you wanna do it like every year for 2 years or something like
Yeah.
that? Like,
Okay.
yeah,
That way, they have to do something before next session, and if they're not done, they have the next.
yeah,
Okay. So, interim report, December 31st of 2022, and then a final report the following December?
yeah,
Okay.
that's good. And then do you need to put in a sunset provision, or are you?
Typically, you'd give a little extra time after the final report so that if the General Assembly decides to extend it in the next legislative session, you can do that without having to reconstitute the task force.
Got it.
So have it expire sometime during session next year?
Yeah.
Okay.
What, Senate Bill 777? It's not in your packet, you have to look it up on the laptop.
I'm just handing out what the voting was.
Oh, sorry.
They're good, I'm just so everybody knows.
All right, you wanna just do top to bottom?
Sure. So the task force will study the cost of producing files relating to law enforcement. There's a better way of saying that. Of producing records by law enforcement agencies in response to Public Information Act requests. Procedures applied by law enforcement agencies in fulfilling requests, and a report on the status of the Public Information Act Compliance Board. The task force will be composed of 2 members of the Senate appointed by the President, 2 from the House appointed by the Speaker, representatives of the Maryland Municipal League, MACO, Chiefs and Sheriffs Associations. Those are 2 separate associations, so just OPD, the Maryland DC Press Association, the State's Attorneys Association, BALT Legal, the Maryland State Police. Do you want the representatives to be appointed by the governor or
Presiding officers.
all appointed by the presiding officers? The task force will report to the General Assembly first in the interim, December 31st, 2022, and then for a final report, December 31st, 2023. Sunset is February or March of the 2024 session?
Yeah.
Okay, So we'll do like March 1st of 2024. And staffed by OAG.
All right, so the motion is to adopt the amendment as described. Sorry, Senator Sidnor.
I just wanted to just say one thing before we move in this direction. I think it's unacceptable that police departments have moved in this manner to undermine what we were trying to do last year and undermining, and I think I will vote for this task force, but I just think it's highly unacceptable that they think that they control what the people have spoken to do. And I just wanted to say that.
I second the sentiment, so thank you for saying that. All right, there's been a motion to adopt the amendment. It's been seconded. The motion is now for a favorable with amendment. It's been seconded. Everyone's okay? Excellent. Okay. Next, we'll move on to Senate Bill 775. Yep.
That's the one I said, but I need the EMT approval.
Oh, sorry. All right, let's go to 772. Did you ask for?
So this bill provides that the use of marijuana by a parent or a guardian other than an individual who cares for the child does not qualify as neglect except under certain circumstances. So it it says neglect does not include the use of marijuana by any parent or individual who has permanent or temporary care or custody or responsibility for supervision of the child unless, as a result of the use of marijuana, the child's health or welfare is harmed or placed at substantial risk of harm, or 2, the child has suffered mental injury or been placed at substantial risk of mental injury. This definition, the 1 and 2, mirror the current definition of neglect, which appears on page 2, line 5 of the bill.
Suggested to me by the division of the Public Defender's Office that represents parents, because this is a real issue, that the simple fact of marijuana use has resulted in parents losing custody of their children, impacted visitation, and even, if you recall the testimony, one specific situation was brought up where even though there was no reason to keep a mother away from her kids at a certain point, because she had continued to test positive for marijuana, she wasn't able to have all of her kids restored. I think the testimony was that she was able to get maybe 2 of them. She had more than that. So I think this is a no-brainer, because as we move toward ending prohibition of marijuana, it certainly shouldn't be a factor in terms of someone losing their kids. I also want to briefly address the concerns that Senator Watson brought up, and happy to discuss it further, but I don't think the concern that Senator Watson brought up about his concern about someone smoking marijuana in front of their kids, I don't think this bill impacts that, because a court can still consider the behavior of a parent regardless of this. For example, alcohol is not a reason for someone to lose their kids or be restricted from visitation, but if the court found that the alcohol use was impacting the ability to care for the kids, then the court could certainly make the determination that the kid shouldn't be with the parent because of the alcohol abuse. So that's my thought on that. Shall I call on Senator West?
Thank you, Madam Senator. Back in the back room earlier, we talked about adding one word to this bill, and the word mere. so that the mere use of marijuana would not cause a disqualification. The overall conduct of the parents would be totally relevant, but the mere fact that a parent had used marijuana, that alone would not be sufficient to affect the decision of the court. Does that make sense? Can you accept that as a friendly amendment?
I'll accept it as a mediocre, no, I'm just kidding. I'll accept it as a friendly amendment, yes.
Okay, thanks.
Heather? Yeah.
Yes.
So line 13, is that right?
So that would be page 2, line 13, after the insert mirror.
All right, great. All right, so now the bill's before you as amended. The motion is for a favorable with amendment. We could do a roll call if you like. Is everyone okay? Or? Okay, got it.
Everybody's good?
Everyone's good. All right, so now we'll go to Senate Bill 465.
Senate Bill 465 repeals a catch-all prohibition relating to licenses to drive and moped operator permits that prohibits a person from doing any act forbidden or failing to perform any act required under Title 16 of the Transportation Article, which governs driver's license and moped operator permits.
But happy to discuss if you want to. I'd move favorable.
Seconded. Sorry, this question, Senator Casserly.
Thank you. So I'm looking by, it says a person may not do any act, all it says is any act forbidden or fail to perform any act required by this title. But I don't see where that's tied into moped, anything to do with mopeds. What am I missing?
I believe moped operator permits are also governed by the title, which is Title 16 of the Transportation Article. It's not in the bill, but
So 16, I'm sorry, there you are down there. I'm sorry, I'm looking the wrong way. Sorry. 16301 is only about mopeds? Is that what you're
no. So 16301, that provision, the subtitle is about violation of various license provisions. So the prohibition itself refers to this title, which is the entirety of Title 16 of the Transportation Article. So it includes provisions related to moped operator permits, but those are not listed in the bill.
Okay, I'm just trying, I don't have the full statute in front of me. So, just to be really clear here, I see that under 14, what we have in the bill, 16301A, relates to moped operators. B, which we have in the bill, relates to moped operators. Then we jump all the way down to Q. And I don't know, does Q only relate to mopeds? Or does it relate to any act?
Q relates to any act which is forbidden or required by the entirety of Title 16, which is essentially every law related to licenses to operate motor vehicles.
All motor vehicles. So, okay, so let's just throw out of this discussion anything to do with mopeds, because it's entirely irrelevant to our discussion here, right? I mean, it's one little piece, so what we're doing
Right.
here is mopeds.
As relevant as any other motor vehicle.
Right, so it seems to me that the whole discussion about mopeds is completely irrelevant to our discussion of this bill, because nobody really cares about mopeds. This bill says this also would relate to any act referred from any act by somebody driving an 18-wheeler, a tow truck, an automobile, anything else on the roads, right?
An act relating to receiving or using a license to operate those vehicles. not an act involved in operating those vehicles.
Okay, so I'm just concerned because we're bringing this forth as a moped bill, but it's really not a moped bill. It has to do with all licenses. And so we're voting on a bill that I really don't know the full impact of it. I know it would affect mopeds, but it also affects a whole lot of other stuff. I'm just trying to understand before we vote for this, what that whole lot of other stuff is. Because we keep talking about mopeds, which is, I don't care about that. It's all the other stuff that we're deleting.
Correct, and it's actually a catch-all provision which relates to all these provisions, almost all of which have their own penalty provisions.
Right. So why do we want to delete a catch-all provision that, because we haven't, when we write the laws, we can't envision every, I mean, some things are left out. We talk about licensing provisions, and we're just saying, well, if you didn't.
Maybe can the sponsor explain the intent?
Sure. Okay.
I don't think it, go ahead.
Yeah, I thought mopeds, as I thought Josh explained, was just one of the potential permits that falls under the bill, but it wasn't intended to be about mopeds. I think it was a general for all licensing, including moped operators. And currently, persons can be imprisoned for up to 2 months and fined up to $500 and assessed 12 points in their license if they do any act forbidden or fail to perform any act required here. According to the information that I received, it's a problem because because it can result in someone being incarcerated for, something very minor.
Is there a case or
It's a catch-all.
situation or an advocacy group that had this happen?
There are, hold up, you can move it to the back, and I wasn't expecting it, so I don't have all my stuff in front of me, but I'm happy to pull it up and look through. The answer is no, it wasn't brought up by an advocacy group. For the last number of years, David Moon in the House and I have been working in tandem to clean up some of the parts of our traffic code that result in unnecessary criminalization and incarceration. And this is another effort in that realm.
Put it on this bill. If it's Moon's bill, stick it on there.
Testimony about Maryland State Bar Association. Was anybody in opposition to this?
No.
Okay, then I withdraw my questions. Thank you.
What'd you say?
I'm fine.
You're good?
They explained that the stuff we really want to punish is detailed, create these punishments. Stuff that if you came before this body and said, well, can we give you this harsh punishment for that? We would clearly say no, but because it's in the catch-all provision, you can get really nailed for doing something that you would have no idea was a jailable offense. So if we want a jailable offense, we should specify that offense, right? So I'm fine. I agree with you, Senator Carter.
Thank you. Nice explanation, Senator Gasly.
No problem. Thanks, Senator Hellman, for referring to me to the provision.
There has been a motion, it's been seconded, and everyone's good. Okay.
Oh, really quick, well,
Uh-oh.
I know we're off of it, but
Yep.
the fiscal note, I knew I had read this before. So there were, in 2021, there were 1,882 violations for this provision and 1 guilty disposition. Thank you.
All right, so we're waiting for B&T approval for 775, so while we're waiting for that, we'll just move on to the rest of the list. Let's go on to Senator Bailey with Senate Bill 517.
I knew that was an accident. Sorry. Ignore the House bill on the voting list.
Senate Bill 517 requires a service provider on request of a law enforcement agency or public safety answering point made on behalf of a law enforcement agency to provide the location information of an electronic device in exigent circumstances. The law enforcement agency or PSAP, that public safety answering point, may not obtain more than 48 hours of location information for an electronic device from this type of request, and a person may not be held civilly liable for complying with the request by providing location information. Department of State Police is required to obtain contact information from all service providers authorized to do business in the state and any other relevant information that would assist law enforcement agencies or public safety answering points in making such a request. State Police must provide the collected information to each law enforcement agency and public safety answering point in the state. There is an amendment in your voting packet. It is Amendment 273227/1, and it, on page 2 of the reprint, provides that this section applies only to a request for location information of an electronic device if the owner or user of the electronic device is believed to be missing. And that is the only change being made there. So it limits the application to persons who are believed to be missing.
So I'll just explain it to you. The issue with this bill, and if you remember, this has been done in 30 other states, and what happens is when the police are looking for someone, especially children or missing people, they request to the service providers that they provide the information. They ping the phone and they get the information back. And unfortunately, that sometimes takes 2 to 3 days because the service providers just don't provide it back. Now, we talked about exigent circumstances. We talked about different offenses that could be committed, and we took all that out. The only thing this says is if there's a missing person, right, and we think they have a device or they're in charge of a device, that device can be pinged to find that person. And that's it, right? And because of the fact, right, it pings the phone, and that way, that phone, we can go ahead and see where it is. Because that's the biggest issue, especially this time of year when we're looking for people. If they're searching for someone and all of a sudden it's 70 degrees tonight, 70 degrees today, but tonight it's 30, right? We don't find those people, unfortunately, and that was what was so compelling with the testimony, that girl that was found 2 days later, and that if she had been found, if they had actually pinged her phone when they pinged it, they get the information, we find them right away. So we just, not for law enforcement, other than search and rescue, that's what we would use this for.
And just for clarity, you said there was a 2-day limit on this? Was there some kind of time frame where you couldn't go back a certain amount of time?
They can only go back 2 days. 48 hours, I think that's right, Jamie?
I mean,
Right.
but what if somebody's been missing for a week? Does that just make their device null and void, that you just can't access it?
So that situation that exists, we could go, law enforcement could get a warrant. They could do all kinds of other things. What this is this dealing with the emergency situation that exists right now,
Okay.
right? We just want that information. We want, the minute that request goes in, we want them to provide it.
So this doesn't require a warrant?
This does not provide.
So they can go right to the service provider and get 48 hours worth of data. Anything more would require a warrant?
Yes.
Got it. Thanks.
Right, and Senator Watson, just for a little bit of background, under the current process for applying for a court order for location information, up to 30 days of location information may be obtained under an order unless it's extended. So that's the judicial process on that.
Thanks. Just a quick question. I like that the bill is narrowed to only be addressing search and rescue people that are missing, but is believed to be missing the proper way to phrase it? Should it not be as a result of a report of being missing?
You could change it to be more specific, that the person, from a technical perspective and an interpretation perspective, if you could do that and instead require that law enforcement have received a report that the person is missing.
I'd have a greater comfort level with that.
I'm fine with that.
Just to reread it, it would say, this section applies only to a request for location information of an electronic device if the owner or user of the electronic device has been reported missing.
Thank you. I had the same concern that Senator Carter had about that language. But the other, I guess what I, maybe the senator can share with me, if there's a missing persons report, generally speaking, what's the timeline from when someone reports someone missing to the police saying that they're, or treating them as missing, and not just an adult who happens to be going out and maybe not wanting to be bothered by people? Because I'm just wondering if something like this could be abused by someone who's maybe just wants to get, maybe a spouse wants to get away from her husband, and you have this situation where he's going to
Like it's a DV situation.
right. So that's what I'm just, because then I'm also looking at this whole line 8 and 9 about the person may not be held civilly liable for complying with this section. I'm assuming that you're talking about the phone company, but I mean, if someone's coming in and misusing this system, maybe somebody should be held liable. So I'm just. Could you walk me through all that?
So I'll tell you, the impetus and the situation for this is definitely when we're dealing with children, or like, let's say, someone that is in need of assistance, where all of a sudden, you realize that your child is not there. You're somewhere, you're at a park, you're wherever you are, all of a sudden your child is not there, right? You want to find that child. And the situation is right now, law enforcement can't, you can make the request, right, but you don't get that request back for days.
Nowadays, because they have those little things that I believe Senator Lee was, I think she had a bill about people misusing those Apple devices to track, right, the tags. So, I mean, you don't necessarily need the police to track your child if you've given them a device. You can put a tag or something on it, right?
So, and as you well know, people always don't use what it is that's available. I have Life 360 on my phone for my children, obviously. But I do know in the search and rescue world that there's a lot of people that are found, just like the testimony of this, where the young lady was found with her phone, right? But they did not have a tracking device on the phone, and the service provider did not provide the data to them until almost 3 days after the request was made by law enforcement.
So going back to the question
Right,
of
and so
you file with police.
So your question is, right, that the person that's checking on their significant other and says they're missing, right? To be a valid missing person that's an adult, it's usually 24 hours in the system before that qualifies as a missing person. That's what it used to be.
And how about for a child?
I don't know that it still exists now, right? With a child is not 24
No
hours.
time limit on a child.
Because
Right.
remember, I don't know if you were here, but once again, bragging, we passed Felicia's law, which took it up to the age of 18, where there's no waiting period when a person under 18 goes missing. They can immediately deem them missing and go looking for them.
So if we put the language, I think that would solve it for the missing person.
Okay.
Because then law enforcement, they'd have to be missing for 24 hours before that could happen.
Okay. And then with regards to lines 8 and 9,
Just, so my reading of that, Senator Sidnor, is that applies to the telecom company complying, does not provide civil immunity for someone who's seeking to abuse this in order to locate a partner or something. Oh, okay.
In the law, why are we providing immunity to the telecom companies?
From working with them, that was one of the concerns that the telecom companies had, that's why they weren't providing the information earlier.
So, well, I'm assuming law enforcement would have to provide them with some sort of information to show, or maybe not, because then, so I'm just trying to envision how this is operating. Law enforcement says, hey, I got a missing person, send me over the information, so there's no offer of proof or anything to the telecom company?
So if you go,
It's just the request.
if you go to the page 3, line 10.
Okay.
The Department of State Police is the contact information for all the service providers authorized to do business in the state, and any other relevant information that would assist law enforcement agencies or public safety answering point in making requests for the location information in this section. So if the information collected shall be provided to each law enforcement agency and public safety answering point in the state. So that's a dispatch office, call answering service. And
But I'm,
that's not just the officer on the street.
So I'm Officer Bailey, I'm calling you, AT&T, I have a missing person. This is their name, send me the information. Is that how it's supposed to operate?
No, I don't, that's not the way I read that. I read that's coming from one of the dispatch centers.
Okay. Okay, thank you.
Where it says the law enforcement agency and the public safety answering point in the state. So it's coming from one of the dispatch centers, the way I see that.
So what we're talking about is, your line of question got me thinking, and I was thinking about what we did earlier about making a false request for dialing 911. The example I was thinking about was like someone that works at NSA and they find out where their wife is or whatever, 'cause that actually happens. And so what happens if I'm a law enforcement officer and I want to know where my wife is, or I want to know where someone is, and I just call up the telecom company and say, AT&T, I need to know where this phone number is right now. She's missing. So there's got to be a penalty for that.
So one of the amendments that we had was an amendment that any person's phone that was pinged, they got notice that their phone had been pinged. So that person would have knowledge that somebody had ever looked at their phone.
No, I get that.
Right, and so I think that's important to put in here, so
Yeah,
that that person would
that's right.
know, right? So that would cover part of that issue with the spouse. And then I agree, Senator, that there should be one more level that exists to say if somebody abuses it.
So it's 9501 of the criminal law article prohibits a person from making false or causing to be made false statements, reports, or complaints that they know to be false in whole or material part to a law enforcement officer. But it sounds like there are two separate scenarios that you guys are talking about. There's the person who reports somebody that they're, I guess, stalking to be missing to law enforcement, so that law enforcement will obtain that information And then there's the law enforcement officer that it sounds like you're worried that they would abuse the system and basically just call the telecom company and say, you know, hey, I'm a law enforcement officer, this person's been reported missing. I feel like those are two different things. So that wouldn't be like a false report. That would just, I mean, it seems like that would be engaging in stalking.
But you're not, but if you just want to, I guess that's kind of stalking, I guess. Well, maybe for the penalty should be a
Person may not
and then
may not make or cause to be made a statement or a request to one of the telecoms. I guess that would be, may not make or cause to be made a statement to a service provider to obtain location information under this section, if the person knows,
That the person knows to be false.
well, I guess you would tie it back to
request.
the location information of the person who uses the device that they're after isn't actually missing.
well, they have to. They could be thought to be missing, but not actually missing. Is the problem? You know what I mean?
Right.
So it's got to be their
I think it has to be affirmatively false or
correct.
fraudulent.
Yes.
I mean,
We're gonna get this. Don't before we're out here. But while he's working on some wordsmithing, some of the language, let's switch back over to Senate Bill 775. Yeah. Sure.
This is being, on bill page 3 of 3, line 4, if we're narrowing this down just to missing persons, then the whole device in the exigent circumstances, I don't know if we need that, nor the reference to exigent circumstances on bill page 2 of 3, lines 23 and 24, because we're just talking about missing persons. I mean, we've defined what this power can be used for.
Yeah,
so
we got the money.
Thank you.
We got the money. Yeah. All right. Here you go.
No amendments, right?
It's the jury bill. Yeah. So we're going to go to Josh, Senate Bill 520, while we're still working here on Senator Bailey's.
Senate Bill 520 authorizes Baltimore City to decrease or raise to a previously established level the maximum speed limit on a road under its jurisdiction without performing an engineering and traffic investigation. The bill also prohibits any local jurisdiction from implementing a new speed camera to enforce speed limits on any portion of a road for which the speed limit has been decreased without performing an engineering and traffic investigation. You have an amendment in your packet that's number 263527/1. This amendment just clarifies the language in the authorization for Baltimore City. It basically rearranges that language to make it clear that they have the authority to, one, decrease the speed limit to any level, or to raise to a previously established level. So in other words, that phrase, "to a previously established level," is only supposed to modify their ability to raise the speed limit, not to decrease it.
To what it was. Right, with, right,
They can lower, so this is so they can lower the speed limit?
yeah.
Statewide version, this is the statewide implication, is that if they do that, then they have to have
So if any local jurisdiction lowers a speed limit without performing a study, they are not allowed to put a speed camera in that stretch of road.
that's.
There's already a speed camera there.
It's new speed cameras they can install.
Yeah, but if you have a speed camera there. You go lower the speed rate there.
Yeah, the language in the bill is implementing a new speed camera.
Yeah, so my concern, I don't know, I mean, why are they doing this? What road are they talking about? Because we just gave Baltimore City a ton of new speed cameras. Why, I mean, the General Assembly, not me. For all you folks driving in from Baltimore County now, all the people driving in from Baltimore County, you got those new speed cameras, and then they're gonna lower the speed limit on that road? What do they need it for? I usually don't care on a local bill, but obviously I care on these speed cameras.
Well, the local part's good, but, I mean, the statewide part is good.
Yeah, but what, is there a road, or, I mean, we actually had this for Montgomery County, and I think we passed it, but it took 2 or 3 years because we hung it up because, quite frankly, we're worried about speed camera stuff.
Well, that's where we landed on the language you see in the bill.
Yeah, but that's for expansion, but if
I
you
know.
already have a speed camera, that's even worse if you drop the speed limit there. That's really gonna be a money trap. And is there like a specific road they came in, they said people are going, with Montgomery County, we only let it go because it was like, there's a specific road, this is where it was, this was the problem. Was that testified to?
City, like, but I don't remember talking about the JFX. No, they were talking about in city neighborhoods. Yeah, but actually, I do have a question if they're talking about the JFX. Sorry.
Brandon's, I remember someone last year saying she was in favor of the speed cameras in the JFX because if people speed, they deserve the tickets.
I've heard that. I stand by that vote.
I'm telling you because I worry about that, and I've noticed, I feel like these speed cameras are set up a lot of places in tricky little spots. Montgomery County's famous for like coming down a hill and all of a sudden there's a speed camera sitting there.
The mayor's letter says that they've come up with a complete streets manual as a guide to identifying corridors ideal for the lowering of speed limits. They're going to be guided by that.
All right, what if you just said that if you do this, you have to remove your camera if it's there unless you do a study. So if you lower the speed limit without the study and there's no camera there, fine. But if you want to lower the speed limit and there is a camera there right now, you've got to do a study.
Fine. I
Okay.
love it.
So if it gets rid of your problem. So if there's a camera there already and they lower the speed.
Your amendment's better than what it currently is. I mean, a study of what?
That's the engineering study that they always do before they.
Down to the city employee pay can you write this up, that it'd be better as 20 versus 25? Yeah, sure.
No, it's like, no, they do like actually, we did this in Tacoma Park Junction, like, it's a pretty elaborate process, it takes a long
All
time.
right, well, that's better.
Okay, Josh, you got it. Senator Bailey.
So I just wanted everybody to remember that they were tacking this on to a process that we have in Calvert County for one section of a road at Solomon's Island that's about a half a mile long, right? That was what they referenced. And I think they said, well, and it's actually almost a half a mile, but they said it's only a quarter mile. When I asked how many miles in Baltimore this would cover, it was a significant amount. I can't remember the exact, but it was quite an amount that they wanted to be able to do this without doing any studies.
So I think on page 4 of the bill, yeah, or the reprint, let me make sure I'm on the reprint. So the new language in paragraph 9, or paragraph 11, sorry, would now read, a local jurisdiction may not, and the new language being inserted will be, enforce speed limits using an existing speed monitoring system, or, and then the existing language, implement a new speed monitoring system, and then you would strike to enforce speed limit, or you'd keep to enforce speed limit. So it would read in full, a local jurisdiction may not enforce speed limits using an existing speed monitoring system, or implement a new speed monitoring system to enforce speed limits on any portion of a highway for which the speed limit has been decreased without performing an engineering and traffic investigation.
Does that conform with what we have in page 2? Is it different then for Baltimore City?
Yeah, so if they use that authority to decrease speed limits without a study, they would then be subject to that statewide provision.
I'm just, highway under their jurisdictions, that would include like 95 and 695 and all those, right?
Those outside of the JFX in Baltimore City, those are actually under the jurisdiction of the state.
Okay.
Senator Hellman was worried about that one road is under this?
It's under the jurisdiction of Baltimore City, yes.
The one where they would just put the speed cameras?
Now we gotta say you gotta remove the speed cameras if you do this.
No, it just says you need a study.
If you choose to lower the speed limit and there is a camera there,
Yeah?
you've got to do that long, lengthy study first before you do it. What the purpose of this bill is to get rid of, to circumvent the study, the engineering
Yeah.
study, and just to do it willy-nilly
Yeah.
to drop the speed limit. So if they do what this bill wants it to do, there cannot be a camera there under the amendment.
Okay, after.
And
even-
and if they want to put a camera there, they got to do a study, an engineering study.
Yeah, but that's what I'm saying. Oh, I see you're saying if they want to put a new one there.
Yeah.
Okay. All right, I'm good. I'm sorry. I'm slow today.
You.
I know, I am admittedly slow. All right, I'm fine with that, but if I was in Baltimore County, I wouldn't vote for that still.
All right, can we adopt the amendment? Is everyone okay? Yeah. All right, so the motion's for a favorable as with amendments.
Second.
Is everyone okay? All right,
feeling they're gonna be like, oh, we don't check, our speed limits are good.
yeah.
Senate Bill 599 authorizes the Motor Vehicle Administration to allow a licensed driver school to administer the driver skills examination for certain classes of non-commercial driver's licenses. The bill establishes standards and requirements for the driving schools and for the individuals administering the examination. The participating school may administer the examination only if, among other requirements, it has entered into a memorandum of understanding with the administration that has not been terminated by either party.
Expressed some trepidation about this. Susan talked a lot about it. Susan, you said you were going to look more into it, right? I know.
It's okay.
had to wait in line, they wouldn't answer.
Yeah, really.
I mean, I had a little bit of trepidation, but I let Susan lead the way, so.
Yeah, I'm fine with it.
No, my question on this bill, I can't remember, was this an issue of capacity where the existing MVAs just couldn't handle the influx of folks who wanted to take it? Because if it's not an issue of capacity, then we're just taking state jobs and giving them to private entities. I mean, that's the way I'm looking at it.
It wasn't a matter of, I think when the sponsor testified, it wasn't a matter of capacity, it was more availability, that in certain parts of the state where you're pretty far from the MVA, and it was, well, if you're not going to put an MVA over here where all these kids can go, they got to go way the heck over there, then we'll work with you to try to put a local thing so they can go there.
Okay, so it's the issue of convenience.
Convenience is exactly what it was.
Yeah, no, so I got this from the MVA. Their wait time on these tests, they're down to, it was 16 days, but they're down to 3 days as of last week. So they've fixed the situation. The MVA.
Across the system?
Yeah, I guess so. I got this from MDOT. So, I mean, they wouldn't just give me for Frederick, I would assume. But, and then so they also say, we understand this is not taking jobs from the MVA, but it will be taking, but it will take jobs from the MVA as it decreases the number of trained CLA examiners we would need to employ because the private sector now will be offering the same service. I mean, generally, I'm actually more open to the private sector doing these things, but I don't like at all the idea that the person that's giving the test is supposed to be a non-partial, non-biased test giver. And if I'm paying you money to teach me to drive, I'm like, the parents could be like, hey, I paid you to get that license. And so I just don't think, I think we've already, I guess I'll say, dumbed down the driving test. We don't even require parallel parking. Apparently we don't even have a trooper with you anymore to do it or whatever. So we've made it pretty easy. And now we're just going to have Ed's driving school is going to be the one that signs off and gives you a license. I'm sorry, but I just think there's something good about having the MVA do it. It's under the state purview. You know it's a professional course, and it's not somebody that the profit incentive, I think, I have a problem with that on this. I know I'm arguing what you all would typically argue, but against the capitalist.
Thank you, Mr. Chair. So the MVA testimony makes it pretty clear that they would have to hire a squadron of additional people to go be around the state and monitor these tests to make sure they're being given properly. So it's not like we're going to save the MEA a lot of money. They're already going to continue to give tests, and they're going to have to hire more people to go and pay, I guess, surprise visits on these driving schools as they're giving tests to make sure the tests are being given right. I'm not sure why we're doing this.
So let me, I like analogy. So when I go out to get registration renewed, I can go to these MVA satellite offices. Are those privately contracted entities, or is that just an extension of MVA at another location?
I believe so, although for like tag and title, I
Yes.
think they do contract, or I don't know if they contract it, but you can go to a private entity for that. But the offices, for the satellite offices are MVA run.
Okay. Okay, thanks.
Just can you clarify one thing for us, council, then, so then this is almost like enabling, right? Because the MVA would have to enter into an agreement for this relationship to exist. They would have to do that.
Correct, so page 4, line 11, so the administration may authorize a licensed driver's school to administer the examination. And then among the requirements for a licensed driving school, on the next page, page 12, they would have to have entered into a memorandum of understanding with the MVA.
So all of the fears that they're kind of putting on paper here, if they exist and they just don't enter into an agreement, they just don't do it. They don't exercise the option.
The other option is we could just move unfavorable on the bill, and then we never have to have the problem with this bad enabling idea.
Very good idea. And that's real. I just, for many reasons that have been stated, I'm uncomfortable with it, and I don't think it's necessary, and I don't think it's a good practice. But I could be persuaded if people, wanted to coerce me.
You mean convince?
Yeah, convince me. I don't, but the thing is, I don't hear anybody speaking in favor.
I'll say this one more time.
Yeah, I don't know why we can't hold it for another day.
I've been saying that all.
So you're for it, Casley? Okay, I'm convinced.
I mean, if you have a piece of,
I've been saying this the entire session.
if you have a piece way out there and they're like, well, this isn't worth it for us, then you say, well, fine, we'll contract it out, that makes sense. I mean,
Every county has an MVA.
some big.
Where would this exist, this problem?
Senator Bailey, you gave a great example of the wait times. So we were, in the fall, we were all the way into the beginning of the year for wait times, right? Over 6 months.
Now it's 3 days.
Yeah, I gotta tell you, I don't believe that, but,
That was precise information. I mean, was
and,
that statewide or was it for a certain jurisdiction?
If you wanna hold it, I'll go back and get the exact information.
call our local jurisdictions and see how long it would take.
Oh, we'll hold it for more information, all right. Okay. All right, look, I tried. All right, we're gonna hold it for a day.
Senate Bill 612 increases penalties and points assessed for violations related to participation in racing or speed contests and prohibits a person from attending any such event as a spectator. The bill also establishes a statewide prohibition on exhibition driving and likewise prohibits a person from attending any such engagement as a spectator. There is an amendment in your packet that's number 913629/1. This is an amendment that was discussed in concept at a prior voting session. So on page 6 of 6 of the reprint, it adds provisions that relate to modifying the exhaust system or other noise abatement device of a motor vehicle. Under current law, a person may not modify such a system in any manner which causes the noise emitted by the vehicle to exceed that as originally manufactured. And additionally, a person may not drive a motor vehicle with a system that's been modified in that manner. So the current penalty for that is a citation, which can be prepaid for $70. The amendment would add an additional prohibition, which is essentially that a person may not modify an exhaust system or other noise abatement device in such a way that the noise emitted by the vehicle exceeds any local law limiting noise levels in the jurisdiction in which the modification occurred. The penalty for that would then be a fine of $200. I think there were some additional amendments being considered.
Well, sorry, go ahead.
We still have the issue about the
Yeah, that's the
attendance,
forthcoming
the
amendment.
folks who
That's the second part of this, yeah.
There is an amendment coming in?
Yeah, so
Okay.
that's the second part of this, but.
All right.
Yep.
Hopefully it just strikes that part of the bill.
You get the muffler put on in Frederick County, and then you're driving around Montgomery County. We have a different law as far as noise than you have. They're in Montgomery County, and somebody pulls them over, and they're like, where did you put this on? And like, we put it on Frederick County. Well, Frederick County, it's okay with ours. Like, how does that work?
So the way that the amendment works is that the current prohibitions, which are that you may not modify the system such that it emits more noise than it did as manufactured, and you may not drive the vehicle if it's modified in that way, those provisions are essentially statewide. So if you could get the ticket for that no matter where the modification was done, the new prohibition, which is specifically about exceeding the noise limitation, which now leads to the increased fine, in that case, the modification would have to occur in the jurisdiction where it now violates the noise ordinance, and that's only applicable to the person who performs the modification.
So yes, so the service provided,
Unless you did it for your own car.
correct.
Cops go, where'd you get this muffler from? Did you do this yourself? Oh, okay.
Question, Josh, has to do with, if we look at A, what the current law is, it says driven on any highway. And your new language does not say driven on the highway.
So the new language is only for the actual modification of the system. So they kicked it, the increased penalty would not apply if you were just using the motor vehicle with the system and driving it on a highway. The increased penalty is for the person who performs the modification.
So my question is, as we talked before, like I have Budds Creek in my jurisdiction. A lot of cars come down there. There are all kinds, right? A lot of them aren't registered, whatever. A lot of those are modified. They fully exceed all the decibel limits, but they're not driven on a car. How are they exempted? They're not driven on a highway. How are they exempted from this if people work on a race car?
They are not, because the modification doesn't, it could be further amended to say, actually, it is exempted, as long as it's not, so that you see in A there, it applies to a motor vehicle to be driven on any highway in the state. And section B, because it requires a violation of subsection A, it incorporates that element. So if the car is never intended to be driven on a highway,
Okay,
it would not violate.
all right, thank you.
All right, so then that's the first part, and then we take away the spectator, it's stricken from the bill.
So that is on page 4 of 6 of the reprint. You would be striking lines 4 through 6, which provides that a person may not attend a race or speed contest as a spectator, and also lines 22 and 23, which is the same prohibition for an exhibition driving engagement.
So that was Senator Cassidy's suggestion, that you could do one without actually be racing, but when you have two components, then you,
That's something different.
sorry,
That goes to the definition of exhibition driving.
yes, okay.
So that would be on page 3 of 6 of the reprint. In the new subsection K, which is exhibition driving means the operation of a motor vehicle in a manner that results in, and then there's a list of 6 things. So you could insert there that results in 2 or more of the following.
Yeah, I thought we discussed revising the definition of exhibition driving in such a way as to say that if it's just a single car, and there's no second car involved, it wouldn't be exhibition driving. So, for example, if I'm moving along on the highway and I see an accident up ahead and I jam on my brakes, that would be an excessive deceleration of the motor vehicle, and it might cause skidding or squealing or swerving or swaying. So, but there would be another car, I wouldn't be doing it in tandem with another car, so I should be okay. If there are two cars and we're racing up the Beltway and swerving around and accelerate, that's what this is about, right? No.
So they pull up to like Towson Town Center, and they're like 20 cars, and they're doing burnouts and
Yeah, no,
circles
I understand that. But clearly, that's what this is about. But I'm saying that if we revise the definition of exhibition driving the way that Josh suggested, it would mean that if I jam on my brakes on the Beltway, I would be guilty of exhibition driving.
that's what I was looking at, but he says it's 2 or more of those factors, right now?
Yeah, you could also potentially add language that intentionally results in the following. So if you're, I don't think that the scenario Senator West described, you'd be intending to cause any of those things.
Well, I would if I jammed on my brake. I would have to accept the fact that there are certain things that would result from that. But what I was suggesting, if it's just me by myself on the Beltway, and I jam on my brake to avoid crashing into somebody, that should not be prohibited. But if I'm racing somebody else on the Beltway and there are 2 of us involved, and we're jamming on our brakes and swerving and et cetera, that should be precluded by this.
The engine of the motor vehicle producing an unreasonably loud, raucous, or disturbing noise.
So I believe it's actually from a bill that was passed a couple of years ago, which applied specifically in Wycomico County during special
Okay,
events.
yeah, all right.
So it's just repurposing that
Okay,
definition.
I got it.
Yeah, we did that.
Work off of that.
Because you've already covered it with
Okay.
the applicability section, so it only applies to the.
New amendment. Yeah.
So I should toss the original.
Correct. Senator.
Just to be clear, when you say working off the amendment, you mean this document, not necessarily the amendments that we were just talking about?
3629/1.
All right.
So that does not include striking out the spectator provisions?
Yeah, I don't have
Okay,
the other, I
gotcha.
don't have the other amendment. Is it in our packet?
No, this was in concept on top of the
Got it.
existing.
Okay, so then now we're strike spectator. Is everyone okay with that?
Yes.
Okay. And then for Page 3 of 6. What was the solution for, it has to be, it can't be just one element, it has to be,
So for that, you would, on lines 8 and 9, you would say the operation of a motor vehicle in a manner that results in two or more of the following.
Senator West?
Just adding the words, exhibition driving means two or more drivers operating their motor vehicles. And then we can go with the language that Josh had. So that would mean that if I'm on the Beltway, I would not be defined as engaging in exhibition driving if I jam on my brakes. And that causes abrupt deceleration, skidding, squealing, swerving. You know, right now, if I do that, I'm within this definition. But if we change it to provide two or more drivers operating them, that means I would have to be, jockeying with somebody else on the Beltway. That should be prohibited.
I mean, my only concern with that is you could have one guy out there doing exhibition driving. He could have his brand-new car out there and doing all kind of fancy stuff, and, yeah, yeah.
And to Senator Cassidy's point, I think you're going down the highway and decelerating because someone's stopping in front of you, causing you to skid. That's not exhibition driving. I mean, I can't imagine a police officer stopping.
That's another question.
But I do think that having to add an additional driver is going to exempt a number of other incidents that we've seen happen.
So you're talking about
So just maybe to address that, if we just add that in the definition, operation of a vehicle in a manner that intentionally results, to add the word intentionally, that way if it's just an accident, you're trying to steer of an accident, somebody's. Well, I intended to stop. I wasn't trying to swerve my goal wasn't to swerve and lose control. My intent was just to slow down.
Yeah, I think you wouldn't be intending to cause like excessive deceleration if it was necessary to avoid an accident, and you wouldn't be hitting the brakes for the purpose of causing squealing, burning, or smoking.
It's an unintended result.
You can put the adjective recklessly in there, but what's the difference between reckless driving, which is already a crime, and someone who recklessly does this stuff?
I mean, penalties potentially, which.
I get what you're saying, because like the kind of the spirit of the bill is you're talking about these big crowds, or you're talking about races, not just some guy just reckless driving. So we're getting a little bit away from the kind of the purpose.
Yeah. Well, that's why I said two or more. That's sort of getting into group effort to perform badly on roads.
That's like drag racing too.
Yeah, right. If you put the adjective recklessly in there, that would solve my problem, because if I'm jamming on my brakes to avoid running into a car ahead of me, that's not reckless. That's reasonable under the circumstances.
I think either intentionally or recklessly likely gets you out of the scenario where you're doing it to avoid an accident. I think recklessly is a little bit more expansive in the sense that if you yourself were driving negligently or recklessly and that's the reason you had to slam on the brake, it might cover that scenario, as opposed to intentionally might not cover that scenario.
Just add the word reckless in line 8 before manner. Exhibition driving means the operation of a motor vehicle in a reckless manner that results in, that. Take that out. I don't need the 2 or more.
I like the two.
You like the 2 or more?
Yeah.
Okay.
There's
Yeah,
just like just
that's
one
right.
person ripping down the street. It's not, it's for these like mass events, you know, it's for.
I missed the hearing, that's what she was talking about.
Yeah, it was kind of more about, in line with the special events that we did before. I don't know if you were on the committee when we did that bill, but there's a race.
Down in Ocean City.
Correct, yeah. H2O, down in Ocean City.
Mary Beth.
It's definitely something we should do about, because, I mean, we had, in Silver Spring, downtown Silver Spring in our town center, this thing happened within a couple of hours, and there were hundreds of people there in the town square. They were setting off fireworks. Yeah.
So if you want to leave the 2 or more there, we would say exhibition driving means 2 or more drivers operating their motor vehicles, 1, in a reckless manner that results in da-da-da-da-da.
The 2 or more of,
2 or more of the following, and then you
Yeah.
have those 6 things.
That's fine.
okay. Can you read that one more time?
So it'd be exhibition driving means 2 or more drivers operating motor vehicles in a reckless manner that results in 2 or more of the following.
That works. Yep.
All right, is there anything else? There's no other response to the amendment, right?
Nope.
Move.
All right, it's been seconded. Is everyone okay? All right, great. The bill passes with amendments.
Okay. Okay, with Senate Bill 6, there is an amendment in your packet. It was one of the amendments that were handed out later.
What bill, Brian?
Senate Bill 6. So it should be handwritten in.
It's House Bill 86.
Yeah, so it says House Bill 86, but there's a slash through it and says Senate Bill 6.
Yeah. Oh, this is too long, move unfavorable.
Senate Bill 6, but I just used the reprint from House Bill 86. So this bill, it does do several different things related to tenant landlord issues. So first, it establishes requirements and procedures for landlords to use ratio utility billing systems. That's page 2 and 4. It requires a statement of costs to include supporting documentation, including things like bills and invoices where practical. That's for deductions from a deposit. That's pages 4 and 5. The bill requires a landlord to allow a tenant organization to assemble in a meeting room within the apartment facility. That's pages 6 and 7. And then where the bulk of the amendments appear is from there to the end, where the bill expands protections for tenants who are victims of assault. So current law applies to victims of domestic violence. So it's domestic violence and a victim of sexual assault. The bill as introduced applied to domestic violence victims of sexual assault, or a victim of stalking. So what this bill does is it deletes those terms and replaces it to a cross-reference to the definition of abuse under family law, section 4-501. So under that, abuse is an act that causes serious bodily harm, an act that places a person eligible for relief in fear of imminent serious bodily harm, assault in any degree, rape or sexual offense, false imprisonment, stalking, revenge porn. So these are the amendments that were proposed in the House. The House has not voted on it yet, but these are the amendments I believe that the House has agreed upon by the interested parties.
Yeah, so I think I'm going to answer your question. So MMHA and the Renters United Tenant Advocacy Umbrella Organization were the ones who together drafted these amendments. So everyone is on
These ones that have SB
6.
6, okay.
Yes, and they're, as you can see, they're originally drafted to the House bill because the House committee is about to move it now that the parties have agreed to the amendments together. So the bill, on the merits, the bill does 4 primary things. It expands lease termination protections for victims of sexual assault and domestic violence. It gives qualified professionals the authority to certify bona fide victims of abuse. It creates new transparency requirements for landlords, including a requirement that landlords who use ratio utility billing provide written notice to the tenants as to what they owe. And it grants the tenants the ability to use community spaces within their buildings for the purpose of organizing tenants' unions. And so, so tenant unions, so tenants sometimes organize together, and the landlords are okay with making clear that that common spaces in the building can be allowed for this purpose. A tenant union, like a tenant association. Yeah. Not like a labor union, I'm sorry. Yeah, I mean, but they'd be tenants, but yes, the equivalent. And so these, the amendments don't alter the underlying purpose of the bill.
No, you can't use the common space. Is that happening?
There are some bad actors in the landlord community who do not allow common space to be used for tenant meetings. But the organized MMHA supports allowing such spaces to be used for that purpose. And are cool with the bill.
Yes, with MMHA amendments, which I've got here. Were they included in these amendments?
Yes, they will.
Oh, okay, good.
Amendments, everyone's okay?
Yes.
All right, so the motion's for favorable with amendment.
Yep.
Second, everyone's good? Okay. Great. All right, we can go back to.
It does not.
So Senate Bill 592, it was the other bill that was handed out late. It has House Bill 932, but that's scratched out and handwritten in as Senate Bill 592. So this is the bill that deals with the form of payment. So the amendment strikes the added language under the bill and specifies that an electronic or written check issued by a political subdivision on behalf of a government entity shall have the same legal effect as payment made by the tenant under current law. The bill also makes the similar changes to the Baltimore City Code.
What's been happening was the landlords were refusing to take money, a payment made by the government, by a local government entity for payment of rent, so they would use that to evict the tenant. But only on the allegation that payment by a local government entity is not in the statute. So this puts it in the statute, where if the local government pays the rent, then it's fine. That's all. It's just a technical thing.
Oh, and I just want to add, these are the amendments that were adopted by the House and passed by the House.
Landlords from refusing a check that's been issued by a political subdivision, like a county, like Montgomery County or Prince George's, on behalf of the government entity solely because it's not one of the forms of payment listed in the statute. This is a real easy bill.
Did you all work out so remember they said that they were afraid that if they were to take this money, that there would be some contractual obligations that would attach? Yeah, that's not in the bill at all. This is only Baltimore City, right? Senator West, go ahead.
Yes, the Multifamily Housing Association had that problem, that this requires them to accept a check, and they're concerned that it might also require them to sign some kind of a pertinent contract. So they wanted the following words. Whoops. Acceptance of the check shall not require the landlord or the landlord's agent to enter into a contract or agreement, which I think is reasonable.
So I guess if they're going to be getting, this is government money? This is government federal pass-through money?
Yeah.
Okay, but then, I mean, then there should be there should be, I don't know what they are. I know you can't have, I know, that's what I'm saying. If you take it, you should have to adhere to some sort of
Right.
standards for
And this
taking government
requires them
money.
to take it.
I understand that. That's the conundrum that we're trying to think.
Right.
Fix it on here. An electronic or written check issued by a political subdivision or on behalf of a government entity shall have the same legal effect as a payment made by the residents under paragraph blah, blah, blah. That's just pretty straightforward, don't you think?
But that doesn't get you out of the obligations that
The
you incur by
contract?
accepting money under this program. And I don't know what the conditions are under this program. Like, I don't know what that looks like.
Chris,
Yeah.
you said you had an amendment,
No, Multifamily Housing Association.
and what does it say? What do they say?
Want me to read it again?
Yeah.
I'm feeling that Susan was correct. If you take the obligation, if you take the money, then it's the same legal status as if you would have gotten paid directly from the tenant. So to me,
If you're basically saying it's in this cash, that makes sense. If you're saying in order to take it, you have to follow a contract, then you're legally obligating them to a contract that.
Because you're saying they have to take the money.
okay.
Right. Want me to read this again?
No, we get it.
You get it.
I mean, I don't know how we get out of it is what we're trying to figure out.
No, this is a real problem. I mean, it's an important issue.
No, yeah. Was this part of the work group discussions?
I don't think so.
No, we didn't.
No, we didn't get into this issue.
It's federal government.
I have a I,
So paragraph 1 says in the amount, it specifies the amount. Paragraph 2 doesn't say that. Shouldn't it say an electronic written issued by political subdivision on behalf of the government entity in the amount specified in paragraph 1 shall have? It's not just any check, it's a check in the appropriate amount in paragraph 1. You can't, the entity can't just pay the current rent, they gotta pay everything in paragraph 1. Just insert after the governmental entity on line 3.5, I would just put after government entity in the amount specified in paragraph 1. So right here, it says, after government entity, in the amount specified in paragraph 1. Paragraph 1 talks about the amount of the check, and this should say the government entity's check is the amount specified in paragraph 1. So I would just insert that, after governmental entity, in the amount specified in paragraph 1. I think so. Would that be, I just offer that amendment to insert on line, right after line 3, right after the words governmental entity, just insert the words in the amount specified in paragraph 1. So we're on page 2, line 3, 3.5, governmental entity, and then insert in the amount specified in paragraph 1.
I don't think that hurts the bill. I think that's fine. I don't think it's necessary because it needs to be a payment, the same legal effect as a payment made by the tenant under paragraph 1, and paragraph 1 specifies that
Right.
the payment needs to be,
I'm just remembering
all
a disagreement.
past dues and
Doing all the
amounts.
landlord-tenant stuff, where that they were making payments for the current month, they were offering payment for the current month, and it's like, no, you gotta pay everything that's due. They were trying to forestall the foreclosure with just the current month's rent, and the landlords were saying, no, we're not taking the current month's rent, it's everything. I would just like to clarify that that's what we're talking about.
I don't think it hurts. But it's, yeah, that would go to
Oh, is it gonna
conference.
screw it up from the house?
Yeah, because they passed it 139-0, so it'll go to conference.
All right, that's all right.
Yeah, because it already links it to paragraph 1,
Okay.
so it would have to be the dues as determined by
That's
the
all right.
court.
Okay.
So then does this
Was the concern. As I read this amendment, I don't interpret it that way anymore because it says the same legal effect as a payment made by the tenant. And when a tenant conveys a check, there's no additional contract terms you're agreeing by accepting that money. Yeah, so I think the bill as amendment addresses the concerns. And that's my understanding from communicating with committee counsel over in the House, that it's in agreement. I'm not aware if there's other issues.
Let's adopt this amendment. Can we adopt the amendment first? If PJC's fine with that.
HA, that they still believe that language should be put in here clarifying that the landlord would not have to sign a contract in order to obtain the check or cash. So back and say, there's a suggestion that you all agreed to go forward without this language in the House. Can you confirm that is the case or not?
All right, well, we'll hold the bill, it'll be first up tomorrow. Okay?
Are we holding it with the amendment?
Holding it with the amendments, as an amendment. So we'll hold it, it'll be the first bill we vote on tomorrow. Let's go back to Senator Bailey.
So, based on the discussion earlier, the potential language would be to add a subsection on page 3 of the reprint that would provide a.
This is Senate Bill 517.
This is Senate Bill 517. A law enforcement officer may not request information under this section if the law enforcement officer knows the owner or user of the electronic device has not been reported missing. And it sounded as though, you're tying that to penalties as well, or?
You could do the same. Yeah.
Okay, so for context, the false report, a false report to a law enforcement officer, which was brought up, at the last time that this was being discussed, is a misdemeanor and carries maximums of 6 months, $500. Stalking, on the other hand, which was also brought up, is a misdemeanor and carries maximums of 5 years, $5,000.
It's a false report, same thing, just mirrored as the false report.
Mirrored as a false report?
Yeah.
So you'd be saying a law enforcement officer who violated it because they knew that the person hadn't been reported missing, would be subject to a maximum of 6 months, $500.
Chris just got an email,
I know.
said they agree.
I saw it, so.
That's fine.
Yeah.
Okay, so what's, I understand this honesty. They were just trying to get.
Actually, it wasn't in the voting packet, but Senator Bailey did mention it. It would just provide that a law enforcement agency or public safety answering point that obtains location information under this section would need to notify the owner of the electronic device that their location information was obtained within a reasonable time based on the totality of the circumstances. So there's no specific time limit, but the owner would be getting notice.
A couple questions. One, if you're talking about the person getting notice, I would expect that would be immediate notice rather than kind of just opening it up and allowing law enforcement to notify them when they want to notify them. Generally speaking, in these types of cases, I'm assuming law enforcement, any other situation would have to get there would be some sort of judicial oversight, right? They would have to get some sort of a warrant. So we're making a big exception here for people who are missing. I'm wondering if we, because I guess the way the bill is currently, there's no real oversight. We're just going to trust law enforcement even though with the penalty, we're trusting that they're going to use this tool properly. So, I'd want some sort of reporting mechanism just to know how often this is happening. Would you be opposed to that?
They're the keepers of it anyway.
Who's that?
The state police is the keepers of this.
No, so we, as a legislator, when you like to know how often this is being used,
That's fine.
let's adopt those and then move on to reporting if you want to do that.
Okay. So provision would read, a law enforcement officer may not request information under this section if the purpose of the request, or excuse me, if the law enforcement officer knows the owner or user of the electronic device has not been reported missing, violator would be subject to a misdemeanor or guilty of a misdemeanor, subject to maximum of 6 months and/or $500 in fines. There was also a conforming amendment, would just strike the requirement for exigent circumstances. That applies more in the context of like entry and searches, because there isn't time to get a warrant. So that probably could just come out on page 3.
Let's do that first.
Yeah.
Can we adopt that? Is everyone okay with that? All right, great. So the Second Amendment,
The Second Amendment is if the law enforcement agency or public safety answering point obtains information under this section, the agency or public safety answering point shall notify the owner of the electronic device that their location information was obtained within a reasonable time based on the totality of the circumstances.
so Sidney reads reasonable time. It's not immediate, but it's reasonable.
What does that mean? See, that's what I mean. What is, I mean, one of the other options is some sort of after-the-fact judicial review or something, where they come in and say, look, we did this, Your Honor. Anyway, reasonable. What about a week? I mean, if the person's missing, they've acted on it. Well, that's true too. Yeah, can we say ASAP? No, I'm joking now.
Is everyone okay? All right. Further discussion? All right, now the bill is before you as amended.
So it's
Sorry, good. Yep. Yeah.
So the First Amendment, this is only applying to persons who have been reported missing. And it would also provide that a law enforcement officer may not request information under this section. So that's the law enforcement officer going to the service provider. If the law enforcement officer knows the owner or user of the electronic device has not been reported missing. So they're doing it under false pretenses. And a law enforcement officer that violates that section or that subsection, that prohibition, would be guilty of a misdemeanor subject to maximum penalties of 6 months imprisonment and/or $500 in fines. The Second Amendment to the bill would provide that if a law enforcement agency or public safety answering point obtains the location information of an electronic device under this section, the agency or public safety answering point shall notify the owner of the electronic device that their location information was obtained as soon as practicable.
Not on this bill, but I think I've got a way to resolve the issues on the last bill.
They're fine with that. Okay. Well, hold on, let's handle this bill first. All right. All right. All right. So there's been a motion for favorable with amendment. Of course.
Go on.
Yep.
What's the no, just the delay. I mean, what prohibits the immediate? I mean, as soon as you get the information, because I'm assuming if they're getting the ping, why can't the person who they're possibly looking for be pinged? Or, I mean, what's that all? Is that a technology type issue, or I mean, you're being looked for. You've been reported missing or something. I don't know. Then again, maybe you don't want that. Yeah, neither do I.
I have T-Mobile, and I get messages from T-Mobile telling me to upgrade my phone. And,
All the time.
yeah.
I mean, they can find you when they want you.
You want a message? Say, you in danger, girl.
And I mean, really, they send those messages, right? Here comes the storm. I was thinking about that too.
It's not a big issue. I think we could play it out in a scenario from one to the other.
Stan, and I like what you're trying to do, but this is an exception to how people usually, usually there's a warrant and everything. We're kind of saying, all right, forget the warrant because this is so important. We want to find you, so we're going to just put all that stuff aside. So I'm just trying to think through what we might be missing or getting ourselves into, because we have good intentions, but sometimes people misuse things. So that's all.
I was lunching. Shelley, you asked to hear all the amendments. Fire a warrant when it normally does.
I can't think.
Again, I totally understand. I'm supportive, but I just want to make certain that we know how it's being
That's
used.
hard to come by around here.
Let's do.
Missing person report in order to be able
Right,
to initiate the process.
right. That was one of the changes that they made.
Just so we're clear, it's as soon as practicable.
Yeah,
Okay.
Is it as soon as practical?
yeah.
Second.
All right, it's been a motion for favorable. It's been seconded. What do you want to do? You want to do a roll call? We did not add the reporting. We should add that.
And then, does it go to the General Assembly, or, okay.
Goes to Charles Sidnor's office.
So,
He'll brief that in facial recognition.
And GoCap?
Funnel it all through GoCap, say a law enforcement agency, this kind of sounds like it.
About how GoCap has all these problems. Maybe, why don't you just send it to us? Let's cut GoCap out.
Well, if you do that, then every law enforcement agency is gonna be sending a separate report to you guys.
Well, we're gonna have to appoint we're gonna have to approve their
What's that?
secretary, so that's great. There you go.
There,
And youth services or something?
it's the Governor's Office of Crime Prevention, Youth and Victim
That's my soft
Services.
landing.
Report to GoCap.
That new position,
Favorable, report to
that
GoCap.
Senate confirmed position, that's my soft landing.
So each year reports to GoCap, GoCap, reports to the General Assembly or to
GoCap
Judd and
website's
JPR.
publicly available. They have like websites and stuff.
Yeah, they have dashboards. That's cool. But wait, what?
It's a go-cat report.
We're
It's
skip-
not favorable.
Roll that bill, roll it, all right? It's been seconded, it's been,
Go. Need a roll call or something?
do we need a roll call, or are we good?
All right.
I would not amend the bill like this and not vote.
All right.
All right, everyone's good. All right, real quick, we got 1 minute here, 2 minutes here. Correct, we'll go back to it. Yes, please.
This is between me and Grayson Wiggins. Grayson, we specifically amended the House bill to avoid having to sign a contract. Me, where in the House bill is that language? Him, the way we read the third reader version of the House, it would not require us to sign contracts, just accept a check. Do you read it differently? Me, the bill is silent on the subject of contracts. Suppose you draft a script for me to execute on the floor of the Senate with the floor leader, getting the floor leader to confirm that nothing in this bill requires the landlord to sign an unacceptable contract with the provider of the check as a condition of receiving the check. Grayson, I can do that. We did the same in the House. So I've asked Grayson to prepare the script. I will execute the script on the floor of the Senate with whoever the floor leader is, and we can pass Susan's bill as is. Does that make sense? We can pass Susan's bill as is. And if Susan is the floor leader, I will ask Susan a question on the floor, and you'll have a script which will provide your answer to my question.
We already adopted the amendments, right? Yes. All right, so there's been a motion for a favorable, it's been.
Second amendment.
With amendment, it's been, second? All right, everyone's okay?
I'll be a no on that one.
Okay.
It's not clear to me. I reserve the right to change.
Anyone else?
Yeah, all right, that's it. All right, have the bells started ringing yet, or are we good?
I think I heard.
Seriously, have they started ringing, or?
I don't know. Luke, can you hear?
I mean, I know our Senate president is very on time. I would not want to disrespect him by not being
They are? All right, voting's over. We'll come back. We'll start off with Senator Bailey's bill first when we come back.
Tomorrow?
Tomorrow. I'm scared, you guys.